Hello students, welcome to this session of Master Mains PYQ. Master Mains PYQ is an initiative of NEXT IAS to help and support the students, right? First of all, I would want to thank you all for this overwhelming support that you have shown towards the program. We have received many answers. We have read lots of good answers. Please keep writing and engaging with us, and also to continue this wonderful initiative, I would request you to engage with us in the comment section and also share this with your peers who still do not know about this initiative, so that they can also benefit from this program, right? So the question that we have taken up for today, it again is a polity question. So this was asked in CSE 2023 GS paper 2, polity question around the syllabus area comparison of Indian constitution with other constitution across the world. So this was question 4 in CSE 2023 this year, GS paper 2. The question was, compare and contrast the British and Indian approaches to parliamentary sovereignty, right? So what is the rationale for this particular question? The question is fairly straightforward, right? But the rationale is perhaps the recent comments made by the Vice President on judiciary overstepping its ambit, criticizing the basic structure, doctrine, collegium system, and basically going on to say that Indian constitution also envisages parliamentary sovereignty. Perhaps that was the rationale for asking this particular question, but that has nothing to do with the answer here, right? The question is very much simple and straightforward. It asks us to compare and contrast the British and Indian approaches to parliamentary sovereignty. So how would you proceed with this particular question? It's a very direct question, right? There is no issue of interpretation of demand here. Now, how would you proceed with this particular question? Now, introduction, you have to decide what introduction you need to write. It should be 30 words, right? Now, coming to the body, there can be two approaches. Some people will write it in a PowerPoint format, and some people would want to write this in a tabular format. Both are correct. There is no problem, right, in using any of the approaches, right? You should have your ideas very clear. That's it. So that approach can be followed. Then you have to conclude the answer. So as far as the introduction is concerned, how would you introduce this particular answer? So you have to pick up the keywords from the question itself. The question basically talks about parliamentary sovereignty. That is the key theme around which the question is framed, right? Now, the best approach here would be to write something about the parliamentary sovereignty, right? You can briefly write about parliamentary sovereignty. So what is parliamentary sovereignty? So parliamentary sovereignty is basically the idea that parliament is absolute or highest lawmaking authority in country, right? So the doctrine of parliamentary sovereignty, it basically envisages that parliament has the de jure powers to amend, right, legislate, or to repeal laws without being challenged or vetoed by any other institution in the country. Now, the doctrine of parliamentary sovereignty is a fundamental focus in both Indian and British systems. Our approaches to the doctrine of parliamentary sovereignty differs. So that difference we need to bring in the body part of the answer. So here you will have to first create a heading, and there is no debate or discussion here. There is just one part, right? So comparison, create a heading, comparison between Indian and British approach to parliamentary sovereignty. Okay, so what is the first point that you need to talk? You need to talk about the source, parliamentary sovereignty, the constitution, right? Constitution. Now, if we look at the British constitution, it is unwritten and it is uncodified. So the British system, the British constitution, the constitution is sourced out of various laws, conventions, historical antecedents, judicial precedents, right? Britain follows a common law system. Common law system is basically various judicial precedents. They are taken up as law. They form the legal framework in the country. Whereas in India, the constitution is written. Written means the bounds are very much clear, right? So that is the first thing that you need to highlight about parliamentary sovereignty, that since Britain has an uncodified, unwritten constitution, parliamentary sovereignty, there are no bounds there. There are no lines demarcated, whereas Indian constitution, it is written. So the lines and the boundaries are very much clear. Now, moving on, drawing from this first particular point, what is the relationship between the parliament and constitution, right? So the parliament, the Indian parliament, if I am talking about, in India, the parliament is basically a constituted authority. So there can be two kinds of entities: constituent entities, constituted entities. Constituent entities, they have supreme powers. There are no limitations on its powers, whereas when an authority is constituted, it has implied limitations on its powers, right? So the Indian parliament is a creation. It draws its authority. It is a creation of the constitution. It draws its authority from the constitution. Whereas the British parliament, it is not a creation of the British constitution, right? So the British parliament is basically a constituent authority. So that aspect that you need to basically highlight. The next important point that you can highlight is the amendability, the amending powers, how it is envisaged in both these countries, how it impacts parliamentary sovereignty. So amendability of the constitution. Now, as far as the British constitution goes, it can be amended by the parliament without any restrictions. Whereas under the Indian constitution, under the Indian system, the constitution can only be amended through an elaborate process that has been given under Articles 368. And here also, it is subject to judicial review. And an added layer of check is the doctrine of basic structure, right? And there is an institutional check also. Both the countries have bicameral system, right? Across the world, wherever you will see liberal democracies, there are bicameral legislature. For example, India, there is Rajya Sabha, there is the Congress in US, right? So a bicameral legislature is an institutional check on the legislative powers of the parliament, isn't it? Now, if you compare the Indian Rajya Sabha with that of the House of Lords, we have House of Commons and House of Lords, that is the upper house in the Britain, right? If you compare that, you will see that the House of Lords, it is not an elected body like the Canadian system, right? The Canadian Parliament. So it is not an elected body, so it lacks democratic legitimacy. Besides that, there have been two parliamentary acts. Parliamentary Acts of 1911 and 1949, they have limited the legal powers of the House of Lords as far with matters to money bill, with matters to withhold any legislation for a particular period of time, right? So it does not enjoy the same powers as has been envisaged for Rajya Sabha in India, right? So this is something that you need to highlight. So the next important point, you can talk about judicial review. Right. Now, as far as judicial review is concerned, there is no concept of judicial review in the British system. Right. So basically, the courts do not have the power to review the decisions, the laws made by the parliament in Britain. Whereas the doctrine of judicial review, it is a part of basic structure in India because of judicial pronouncement in Keshwanand Bharti. And also, judicial review is implicit in the constitution. The idea of judicial review is implicit in various provisions like 13, 32, 226, 131 to 136, right? 143, etc. Right? So many provisions across 372, so many provisions in the constitution. The idea is very much implicit. So, because of judicial review, the parliament cannot just frame any law arbitrarily. The judiciary has the power to check whether the law or an enactment made by the parliament goes against the basic structure or is unconstitutional or right on certain grounds, and it can declare such laws as void, right? So judicial review is a very important check on parliamentary sovereignty in India. Next comes parliamentary supremacy. Parliamentary supremacy. So, as far as a British Parliament is concerned, it is the supreme legal authority, right, to enact any law, and there is no authority, entity, or institution that can challenge or overrule its decisions. Whereas, under the Indian constitutional scheme, Parliament is not the supreme authority, and the Constitution lays down checks and balances between various organs of the state. So, under the Indian system, there is checks and balances, right? So, because of this checks and balances from executive and judiciary, the parliament cannot come up with any legislation it wants. And this checks and balances, also called functional separation, right? India does not have a rigid separation of power. It has a functional separation of power that has been held in various cases like Ram Javaya Kapoor versus State of Punjab, or you talk about Keshwanand Bharti. This separate kind of separation of power has held to be part of basic structure, right? So because of separation of powers, right, the Indian Parliament cannot just enact any legislation. It will be reviewed by the judiciary. There is a check by the executive, etc. Now, just to substantiate this parliamentary supremacy in the British system, there is a very important case. The case was Blackburn versus Attorney General. You can take reference to this particular case, Blackburn versus Attorney General, 1971 case. This was the year when Britain acceded to the Economic Union, right? It signed the Maastricht Treaty, and this particular case basically challenged that, the authority of the parliament to do so. And in this particular case, the court there said that the parliament's supreme sovereignty, it meant that the parliament can enact, repeal, or legislate any law that it wants. And judiciary's power is very much limited. Its jurisdiction is very much limited to review the powers of the parliament when it is basically exercising its prerogative powers, right? So the judiciary has no jurisdiction when the parliament in Britain, it is exercising its rightful powers, right? So that was held in the Blackburn versus Attorney General case. So it establishes, this particular case, it establishes parliamentary supremacy in the UK system, right? So what is the next argument that you can talk about? The next argument that you can talk about is how the division of power works. So if you look at both the systems, I hope you already know that the Indian system is a federal system, whereas UK constitution, it envisages a unitary system. So we have unitary versus federal systems. Now, we talk about unitary system, so this essentially means that there is no division of powers between the union and states, right? Whereas in federal system, there is a clear division of powers which is envisaged in the 7th schedule of the Indian constitution. So because of this division of powers, because of this federal nature of our constitution, and the federal provisions in the constitution and the seventh schedule, the parliament cannot enact legislations on state subject. So this limits the parliamentary sovereignty again, right? So you can include that point, this point also. The next and the last point that you can highlight here is constitutionalism and parliamentary sovereignty. So we all know that Indian constitution envisages, the founding fathers envisaged constitutionalism. So constitutionalism versus parliamentary sovereignty, right? So the parliamentary sovereignty in India, it is very much balanced by constitutionalism. So what is the idea behind constitutionalism? Constitutionalism essentially means limited government. So there is separation of power, there is judicial review. So all these provisions essentially limit. Over and above, what has happened is after the Keshwanand Bharti, from IC Golaknath case to Keshwanand Bharti to Minerva Mills to IR Coelho case, constitutional supremacy has been clearly established by the judiciary. So at present, we can clearly say that the Indian constitution envisages a system of governance that is not judicial supremacy as there in the US constitution, and neither it is completely a parliamentary sovereignty as there in the British system, right? So India has a constitutional supremacy. So this has been established through various relevant landmark judgments. Constitutional supremacy. Whereas if you look at the British system, the supreme authority there is considered the voice of the people. There are no constitutional limits, right? There are no constitutional limits on the authority of the parliament. However, the parliament has enacted certain laws there, right? Here, it is prescribed in the constitution. Here, there, in the UK, constitution, the parliament has enacted laws to limit parliamentary sovereignty. So some of those laws that you can talk about is devolution of powers to Scottish Parliament, right? Or you can talk about Human Rights Act of 1998, or the very act that UK government established a Supreme Court in 2009, right, which ended the House of Lords powers as the final court of appeal, right? So it is the UK Parliament that has limited its powers there through various legislations, unlike the Indian constitution, Indian system, right? So this completes the discussion of the body of the answer. Now conclusion, that is something that you need to basically summarize that what you have written in your answer, the idea that you have covered in this particular answer. The conclusion will be simple here. So how would you conclude? Okay, so as far as the conclusion is concerned, it is a very important part of your answer. That is the last thing the examiner will read. So you should clearly summarize what you are trying to say in your conclusion. So as far as the Indian constitution goes, it is a supreme authority. That is the idea that we have covered in the entire answer, right? So Indian constitution is the supreme authority, right? And it is driven by various principles, right, of separation of power, judicial review, right, basic structure, and therefore this system, it basically envisages that there is parliamentary sovereignty but is subject to various kinds of checks and balances by other organs of the state, such as the executive and the judiciary, right? So this is the idea that you have to establish in your conclusion, that the Indian system, it basically envisages a more inclusive, accountable democracy, and it upholds the idea of constitutionalism, right? thank you. We just completed this particular answer. Thank you for watching this video. And as I said, please do like the video, please share, subscribe, and do share this initiative with a lot of people. If a lot of people engage with us, it will be really a wonderful experience, right, for everyone. So please do comment if you have any doubts. We definitely take doubts in the comment section also. Thank you.